On September 24, 2007, federal prosecutors in South Florida signed an agreement with a Palm Beach financier. The agreement said that if he pleaded guilty to state charges, the federal government in that district would not bring federal charges against him. And the young women whose accounts had built that federal investigation were not told the deal existed, not before it was signed, not for a long time after. That's not an allegation from a documentary. That's the finding of a federal appeals court in a written opinion you can pull up right now. Everything that has happened since, every unsealing fight, every headline, traces back to that one piece of paper. By the end of this, you'll understand something that almost never survives the news cycle. This story is not really about one man. It's about a paper trail and about how the American legal system decides what the public is allowed to read. Because the reason this case keeps clawing its way back into the headlines isn't new evidence falling from the sky. It's that documents created 20 years ago were sealed, and sealed documents don't decay. They sit in court custody, waiting for a judge, a statute, or a subpoena to pry them open. And every time one opens, the story restarts. The popular version goes something like this. A wealthy, well-connected man committed serious crimes, got a suspiciously light sentence in Florida, walked free, kept offending, was finally arrested by federal prosecutors in New York in 2019, and died in a Manhattan jail cell before trial. Then, the story goes, a list appeared. A single master document of powerful names hidden in a vault, dribbled out to the public in pieces. That's the version that circulates. And the first half of it is broadly right and matches the court record. It's the list part where the record and the rumor stop agreeing, and that gap is where this whole episode lives. So start where the documents start. Palm Beach, mid-2000s. Local police open an investigation after a report involving a teenage girl. That investigation grows. It moves to federal attention in the Southern District of Florida, and what the federal record shows is that prosecutors there did not go to trial and did not go to a federal grand jury for an indictment. Instead, on September 24, 2007, they executed a written non-prosecution agreement. He would plead to state charges. Federal prosecution in that district for the conduct specified would not happen. He served time in Florida custody on terms that critics have argued for years were unusually permissive. Here's where it stops being an ordinary plea deal. There's a federal law called the Crime Victims' Rights Act, passed in 2004. It gives victims of federal crimes specific rights, including the right to be treated with fairness and to be reasonably informed about the case. And in 2008, victims went to federal court in Florida arguing prosecutors had violated that law by keeping the agreement from them while it was being negotiated. That lawsuit did not resolve quickly. It ran for more than a decade. And along the way, it forced the government to produce material about how the deal was made, which is a very different thing from a leak. In 2019, a federal judge in the Southern District of Florida ruled that prosecutors had violated the Crime Victims' Rights Act by failing to confer with the victims about that agreement. Read that again. A federal court held that the government broke a federal victims' rights statute in the handling of this case. But the ruling came with a hard limit. Finding a violation and undoing the agreement are two separate questions, and the courts wrestled for years over what remedy, if any, was even available. And that fight kept going after the man at the center of it was already dead. Because in 2019, two other things happened, almost on top of each other. Federal prosecutors in the Southern District of New York brought a fresh indictment, a separate district, and separate charges. And that August, he was found dead in his cell at the Metropolitan Correctional Center in Manhattan. The medical examiner ruled it suicide. The Justice Department's Inspector General later examined how the Bureau of Prisons handled him and documented serious failures in his custody, which created a strange legal situation. The defendant was gone, so the criminal case died with him. But the paper generated around him was still very much alive and still sealed. And this is the part people miss. The single richest vein of documents in this whole story didn't come from a criminal prosecution at all. It came from a defamation lawsuit. A civil case, Giuffre against Maxwell, filed in federal court in New York in 2015. Civil litigation generates depositions, exhibits, motions, filings that criminal cases often never produce. That case settled. But the record it created stayed in the court's custody under seal. And once a document sits in a federal docket, the public has a recognized interest in seeing it, which means someone can go to a judge and argue for unsealing. Someone did. News organizations, including the Miami Herald, pushed for access. In 2019, the Second Circuit Court of Appeals ordered the unsealing of a large tranche of material from that civil case. More followed over the years, ruled on document by a federal district judge who worked through which names and passages could be released and which had to stay protected. In late 2023 and early 2024, another wave of those filings came out and dominated the news for weeks, reported as a bombshell, presented online as the list. It wasn't a list, it was court exhibits, and understanding why that distinction matters is the whole point. Because a court exhibit is a claim someone made under oath or a document someone filed to support an argument. Being named in one can mean many different things. It can mean an accusation. It can mean you were a witness. It can mean you flew on a plane or attended a dinner, or your name came up in a question a lawyer asked. The judge overseeing the unsealing drew those distinctions carefully. The internet did not. And that gap between a docket and a headline is exactly how a story gets simultaneously more famous and less accurate every single time it resurfaces. Then Congress got involved, and the mechanics changed again. Because there's a category of material that courts guard more tightly than anything else: grand jury material. Under federal rules, grand jury proceedings are secret by default, and judges have limited discretion to release them, which is why some requests to unseal that material were denied. It isn't a cover-up when a judge says no. It's a rule that protects people who are investigated and never charged. But it also means that for years, the answer to why don't they just release everything had a genuinely boring legal answer. Until lawmakers decided to write a new one. In November 2025, Congress passed legislation directing the Justice Department to release its files related to Epstein, and it was signed into law. That's the hinge, not a leak, not a hack, a statute requiring disclosure, with carve-outs for victim identity and for material tied to ongoing investigations, which is precisely why 2026 keeps producing headlines. Releases under a disclosure law don't arrive as one clean drop. They arrive in tranches, with redactions, with disputes over what the carve-outs cover, and with fights over whether the department has complied. Every tranche is a news cycle. and every redaction is an argument. So here's what really happened, and it's stranger than the rumor. There was never one hidden master file that someone was sitting on. What existed was scattered material across at least 4 separate places. A 2007 federal agreement in Florida, investigative material from a case that ended when the defendant died, a civil lawsuit's sealed exhibits in New York, and whatever the Justice Department held internally. Different judges, different rules, different districts. The reason this story never ends isn't that someone keeps hiding it. It's that the record was never in one place to begin with, so it can only ever come out in fragments. Which brings us to why it stayed buried in the first place, and the answer is uncomfortable because it's mostly procedural. The 2007 agreement was kept from the victims during negotiation, and a federal court later found that violated the Crime Victims' Rights Act. But the secrecy that followed wasn't one dramatic decision. It was sealing orders, protective orders in civil litigation, grand jury rules, and the ordinary practice of not publishing investigative files on people who haven't been convicted. Each rule, defensible on its own, stacked together around one case, they produced something close to a wall. Nobody had to build it. It assembled itself. And there's a second reason, less about law and more about how newsrooms work. For years, the reporting was scattered across local Florida coverage, and legal filings almost nobody read. It took sustained work, including the Miami Herald's 2018 investigation, to reassemble the picture and find the women whose accounts hadn't been heard. Which is a real lesson about buried history. It usually isn't sitting in a vault. It's sitting in public dockets, in county courthouse basements, in filings that require somebody to read 300 pages before they know whether page 200 matters. Most of the time, nobody does. Now the honest part, and this channel doesn't skip it, what the record does not settle. It does not settle who among the many people named in civil exhibits did anything wrong, because being named in a filing is not a finding. It does not settle the full scope of what the 2007 federal investigation had gathered, because that investigation ended without a trial. It does not settle what remains withheld under the disclosure law's exemptions, or whether every withholding is justified, because those arguments are still live. Anyone telling you the whole thing is now known is telling you something the documents do not support. And it does not settle the question that hangs over the earliest part of the story. Why did federal prosecutors in one district in 2007 choose an agreement over an indictment? There's an internal Justice Department review of that decision, and reporting and litigation have circled it for years. But motive is the one thing paper is worst at proving. You can document what was signed, when and by whom. You cannot document what someone was thinking when they signed it. On that, the record genuinely does not settle it, and I'd be lying to you if I said otherwise. So this isn't a story about a list. It's a story about how a legal system can follow its own rules, step by careful step, and still end up keeping the people most affected in the dark for years. That's the part worth remembering the next time a tranche drops and the headlines catch fire. If this is the kind of history you want done carefully, subscribe, because next time we're going somewhere older and colder. A government inquiry into a disaster that produced 2 official reports, years apart, with 2 different death tolls. And only one of them was meant to be read.